So, you want to be a trial attorney, also known as a litigator. Hi, law students. My name is Amina Jones. I am a licensed attorney here in the state of New York, and I am a litigator. And when I was in law school, I was on the Trial Advocacy Board. So I just want to share a few things that I learned about objections in being a litigator, observing colleagues in the courtroom, and being on the Trial Advocacy Board that I hope will help you in your journey to litigation. So the first thing that I would share with you is to anticipate. That is right. You want to anticipate those objections. And it sounds so obvious, but if you've already taken evidence or if you've ever heard anyone speaking of evidence, they always tell you how difficult and overwhelming it is, which can be troublesome if you want to be a trial attorney, because you realize that to be a great trial attorney or any attorney worth their salt, you have to know what to object to. And if you aren't sure what an objection is, the purpose of an objection is to make sure that the fact finder is being presented with the right evidence or the right set of facts. The case, the fact finder is the jury, or it could be a judge if it is a bench trial and there is no jury. But the fact finder is a person who assesses the evidence and determines the outcome of the case. So you just want to make sure that the fact finder hears the correct evidence. With knowing that and then learning the rules of evidence, this can seem extremely overwhelming. However, if you're an effective trial attorney, you should already know your case inside and out. And not only your case, you should have prepared to understand opposing counsel's perspective as well. If you are opposing counsel, what type of evidence or facts would you want to come out in this case? And then from there, determine where you would make objections when hearing them present their case and where they would make objections when hearing you present your case. Even if you know, or even if you've taken your time to make sure that your questions were not objectionable at all, trust me, they will still object. You need to know where they're going to object and why your questions are not objectionable. And you shouldn't come up with 20 questions and out of the 20 questions only have 5 questions where you say, I feel like they're going to object here. Every single question that you ask, you need to have a rebuttal or response if they do object. That is the essence of being an effective litigator when it comes to objections, anticipation. Don't feel as though you have to know the rules of evidence all at once, but you need to be able to anticipate what objection opposing counsel is going to make and what objection you should be making. However, if opposing counsel is examining the witness, meaning if they're asking a witness question, whether it be on direct examination or cross-examination, and they say something or ask a witness something, or the witness says something that doesn't sound right, but you can't think of that particular rule, go ahead and object anyway. There's more harm in sitting in your seat and staying quiet because you aren't sure. There's more harm being done there as opposed to objecting and possibly being wrong. And then you'd likely have co-counsel. And if you don't have co-counsel and you object, there's a chance that the judge may just sustain your objection and basically assume that you know what you're talking about and sustain your objection. So go ahead and make that objection anyway. And of course, if you're overruled, you want to also make a continuing objection, meaning that you're not going to continue objecting over and over and over again if opposing counsel or the witness is speaking on the same subject that you thought required an objection in the first place. You would just let the judge know that you're making a continuing objection. So should you need to appeal the case, or should the case need to be appealed, even if you aren't the attorney on the appeal, then that is noted. So that isn't a moot issue. We'll get into that into another topic. I'm not an appellate attorney, but I know at least that a continuing objection should be made. Or if you aren't sure what the rule of evidence is, go ahead and make that objection anyway. Now, if you're examining a witness, meaning whether it's direct examination, so it's your witness, or cross-examination, meaning it's opposing counsel's witness, and opposing counsel objects to your line of questioning, and you've won that objection, so the judge agreed with you as to why there shouldn't be an objection here and overruled opposing counsel's objection, don't be so excited that the objection was overruled that you move on to the next question, especially if the witness hasn't yet answered you. Of course, you know what the answer is going to be. That's what effective trial attorneys do. You're asking questions you already know the answer to. You would never ask a question you don't know the answer to. But don't be so excited that you won or that the objection was overruled that you move on to the next question, and that answer that you were looking to put on the record and present to the fact finder is never heard by the fact finder, and you're ruining your case because you're so excited. I understand you can be nervous, but take your time. Time is on your side. Take your time. Do not rush it. And the Trial Advocacy Board, of course, you're doing it to sharpen your skills and you're doing it for competition. But in real life, these are people's livelihoods. People's lives are on the line, whether it's a civil trial, meaning that there's a suit for money, or if it's a criminal trial, people's lives are on the line. So take your time. Don't be so excited that the objection was overruled that you forget to get the answer. I would also say create an outline as to what evidence you want and expect to come out in the case, especially the evidence that you want to come out in the case. Because on the Trial Advocacy Board, I'm pretty sure you'll be told, don't read your questions. In the real life and when you're practicing, attorneys read their questions all the time because, again, people's lives are at stake, so they don't want to miss anything. However, if you are the type of person that just prefers to go off the cusp, make sure that you create an outline so that you know what evidence you want to come out in the case. This goes also with the fact that you don't want to be so glued to your line of questioning that if the witness says something that contradicts a prior testimony or a prior statement, you disregard that and move on to the next question that you wrote down. You want to be adjustable and you want to be flexible, and you want to make sure that you're actively listening to the witness so that you can shape your case accordingly. Now, speaking of asking questions that you don't already know the answer to. When I was in Portsmouth, Virginia, I was doing traffic trials, right? And I already had my questioning lined up. I never met this client. People don't take traffic violations seriously. They never came. To this day, I still haven't met them. Anyway, I had my line of questioning already, and there was one police officer, but there were other attorneys that were asking, that had their own trials examining this police officer. And every single attorney in that courtroom, their first question was, "Officer, my client was cooperative, wasn't he or wasn't she?" And the officer would say, "Yes, she was," or "Yes, he was." So I said, fine, I'm going to ask that question too. So I got up there, and I'm pretty sure you could already see where this is going. I said, "Officer, my client was cooperative, wasn't she?" And he said, "No, she wasn't." And I was so shocked. Like, how could I be shocked? Because he was asked this question so many times already. I just knew he was going to say yes. And he might as well slap me in my face. That's how hurt I was. He's like, "No, she wasn't." So I was like, "Yeah, but she answered your questions, didn't she?" Like, I'm trying to do damage control, okay? So I made two mistakes there. First is asking questions that I don't know the answer to. So please do not ask any questions that you don't know the answer to. Effective trial attorneys do not ask questions they don't already know the answer to. We have discovery. We have investigators now. If you ask that question, you better know that answer because you don't want to screw up your case, okay? Second mistake that I made was trying to do damage control, because it got to a point where it sounded like the officer and I were arguing, because I said, "But she answered your questions, didn't she?" And he goes, "Not at first, but she eventually did, didn't she?" You know, it sounds like my Trial Advocacy Board coach used to say, it sounds like you're dancing with a pig and you're getting dirty. And I'm not using the term pig because it's a police officer. You're dancing with a pig and you're getting dirty, right? So don't do that. You're ruining your case. If you hear an answer that you don't like, even if you know the answer already, right? If you hear an answer that you don't like and they didn't answer it the way you expected them to answer it, remain professional and move on. If it's especially, her being cooperative had nothing to do with anything. You know why? Because we were already at trial. And this was for reckless driving. Her being cooperative had nothing to do with anything. Like, let's be real. So if it isn't substantive, if it isn't important, and it is not going to have a true outcome or weigh the outcome of your case, move on. Do not argue with the witness. You want to be professional. Even if it's opposing counsel's witness, you want to get up and say, good afternoon, officer so-and-so. Be respectful, be professional, because that is what is going to be effective in the outcome. My last point is, if you have a line of questioning and you feel as though you're going to be objected to, feel free to ask the question anyway, because one of two things could happen. One, opposing counsel probably they didn't see this video and they're too afraid to make the objection. That's number one. Like, three things. So they're either afraid to make the objection. Two, they don't even realize what you said is objectionable. Or three, they make the objection. The judge sustains four things. The judge sustains the objection, meaning that the judge agrees with opposing counsel. But guess what? If it's a jury trial, the jury already heard the question. So now they're wondering, like, yeah, what was going on there? So ask the question anyway. But the fourth thing is that the judge could overrule the objection. I mean, judges, contrary to popular belief, judges don't know everything. So the judge could probably not even realize what the issue is and overrule the objection. So those are my tips as far as litigation and trial advocacy. I hope this was helpful. I wish you the best in your journeys, and I will talk to you soon. Please follow my pages, My Lawyer Amina and Black Girl at Law. I love you guys. Talk to you later. Bye.